Good morning, everybody. You are indeed very welcome to this, the latest in our series of webinars focusing on the built environment. And while today we are looking at commercial leases and insolvency and what the practical implications of that are, we have, over the course of the last number of weeks and months, also brought you a series of webinars looking at all aspects of the built environment sector. We've looked at the implications for residential lettings in the context of PRS, multifamily, built to rent, commercial lettings, the hospitality sector, the implications of the current COVID pandemic for construction contracts, development finance, and planning. And links to all of those slides and recordings are available on the Mason Hayes & Curran website. For those of you who tuned in earlier in the week, we had a session on construction contracts and insolvency and the interaction between the two at the moment. And while I'm sure some of you noticed with much regret that I didn't moderate that session, it was indeed my colleague Micheál Grace who did that. You might let us know who you thought did better as moderator at the end of this, unless you thought it was Micheál, of course, and I'll feed it back to him. But thankfully, with the same eager anticipation that awaits Ray Darcy's return to Den TV this October, we are back today with commercial leases and insolvency. And while we don't have Zig and Zag with us, we do have my illustrious colleagues Davy, David Ormsby, and Colm Farrell. Tom is a partner in our real estate department. David Ormsby is a partner in our commercial litigation department, specializing not just in insolvency, he's pointed out, but also, very importantly, restructuring. He's not all doom and gloom. And we have Colm Farrell, a senior associate in the commercial litigation department, and Colm specializes in dispute resolution with emphasis on landlord and tenant disputes, residential, but more importantly, and for today, commercial. As always, we're trying to keep this session interactive, and thank you very much to those of you who, as part of the registration process, submitted some questions. We've tried to work those questions into our session here this morning, and to the extent that we haven't, we'll try to pick them up at the end. Also, if you happen to have questions as we go along for our panelists, do please insert them into the Q&A, the chat function at the bottom of your screen, and again, we'll try to get to those at the end. So I suppose in terms of setting the scene, not just in Ireland, but generally, the current pandemic has resulted in a crisis for the commercial leasing sector, in particularly for retail tenants. Not so much, some would suggest, for office tenants, but certainly in retail, there has been a significant degree of pressure brought to bear. There are rents are in arrears across the board. Landlords are struggling. Lenders are playing ball. And I think that's the overall point, that at the moment there has been a collective, with some exceptions, a collective we are all in this together kind of approach to it. But as things continue on, and as cash continues to be in short supply for some retail tenants, and that the natural effect that's going to have on those landlords, and in fairness, their lenders, what's going to happen in the short to medium term? As the government subsidies come to an end and get wound down, as mortgage breaks come to an end, I think we're going to see an inevitable clash of interests. And I suppose it's that clash of interests that we're going to talk about today. And I think firstly, Tom, I might ask you in the first instance, perhaps just to set out what legal impact the pandemic has had on commercial leases in terms of setting the framework for the conversation here this morning.
Yeah, thanks, Jamie, and good morning, everyone. Thanks for joining us today. I think a couple of points at the outset, Jamie. One is just to note that there's no specific COVID-19 legislative protection for commercial tenants. There was a little bit of confusion caused by the emergency measures legislation earlier in the year, which was aimed at protecting residential tenants. It's since been clarified that it applies only to residential tenants and not commercial tenants. So no legislative protection for commercial tenants. If you contrast that with the UK position, where a moratorium on the forfeiture of commercial leases for unpaid rents was recently extended to the end of this year, I think while there's no legislation at the moment, we do understand that the Irish government is due to publish a code of practice for the retail sector over the coming weeks, and it'll be interesting to see what that might contain. I think the other point is around force majeure, and it was a topic of much discussion over recent months, and whether tenants could avail of it as a sort of an overriding remedy or relief. And in reality, a tenant can't, unless there is a specific force majeure provision in a lease, which would be quite unusual, I think it's fair to say. So in a nutshell, really, despite the huge economic impacts of the pandemic so far, really the landlord and tenant relationship remains governed by the terms of the lease.
And then what are we seeing in practice, Tom? What's coming across your desk?
Yeah, well, I think, look, that's the sort of strict contractual position. I think in reality, landlords are a good number of landlords are engaging with tenants in an effort to avoid some of the insolvency processes that David is going to describe for us shortly. And in a nutshell, to keep the tenant business going and allowing it to trade through these very difficult times, rather than be faced with an empty premises and perhaps some difficulty in reletting it in due course. As part of that negotiation process, tenants are, as you might imagine, typically required to produce financial information to show the effect of the pandemic on its business, and to share that with the landlord as they sort of negotiate, shall we say, concessions outside of the lease. Interestingly, a survey recently by Retail Excellence found that in the retail sector, at least, 67% of tenants had still not agreed deals with their landlords in relation to rent payments for the period of forced closure over recent months. So while there are deals being done outside of the terms of the lease, there's still a good distance to go in reality.
And what kind of deals, kind of in terms of specifically, are you seeing?
Yeah, I suppose specifically, Jamie, what landlords and tenants are doing, or as far as we can see, is they're agreeing rent deferrals, rent abatements or waivers, possibly a further rent-free period for a tenant. It might be something as simple as altering the timing of rent payments, so from quarterly in arrears to maybe monthly in arrears, or in some cases, or I beg your pardon, quarterly in advance to monthly in advance, or in some cases changing that to monthly in arrears. In the retail sector in particular, there's a move towards turnover rent provisions, which operate typically on the basis of a fixed rent, or base rent as it's known, which would then be topped up by way of a rent calculated as a percentage of turnover in the given store. I would say that from a landlord perspective, they are to a large extent voluntarily entering into these negotiations because they're not obliged to, as I say, under the lease terms. And in those circumstances, a landlord will often look for something in return. And that might involve the pushing out of a tenant break option, the extension of the term, or indeed inclusion of a landlord break option as a sort of a quid pro quo for the arrangements with the tenant.
So it's a practical and pragmatic approach that parties are taking versus being forced with either a vacant unit and the landlord having to pick up the ongoing cost of that.
I think that's it exactly, Jamie. You know, while the lease terms might say one thing, this in reality is what is happening in practice.
And Colm, like Tom's outlined, I suppose what both himself and myself are seeing in terms of the deals which are being done. From your perspective, with one eye further down the road, I suspect, the importance of correctly documenting whatever deals might be done. Can you talk us through that from your perspective?
From a litigation and dispute perspective, just certainty is absolutely key, and that's where documenting comes into it. The parties will have spent a considerable amount of time and effort in documenting the terms of the original lease, and the same care and attention should really be afforded to any two revisions of the lease. So if there is a dispute down the line, for example, around arrears of rent, what you'll want to avoid is that straightforward, or what should be a straightforward dispute, being contaminated by uncertainty around what was agreed or what wasn't agreed. And from my perspective as a dispute, in terms of dispute resolution, what I'd also like to see is a dispute mechanism or default mechanism, So if, for example, there's been a rent reduction and the landlord is going to pursue that, is the landlord entitled then to claim the entire rent that was properly due under the lease, or is the landlord only entitled to claim this new reduced rent? So again, just very clear, very plain English and absolute certainty as to what was agreed between the parties.
So I think, Colm, it's fair to say, and it's a point well made, that what we have seen in a number of these deals is where a concession, in particular on rent, has been agreed. That concession is typically, at least from a landlord's perspective, conditional upon ongoing compliance by the tenant, i.e. ongoing repayment of rent.
That's it. I think that's a great mechanism to actually keep the tenant honest and to keep them honouring the revised terms going forward.
And Tom, from your perspective, from a real estate perspective, leaving aside the points which Colm has mentioned, are there anything from a property centric world that we need to consider or that we need to see in those documents?
Yeah, I suppose a couple of words on how specifically these arrangements are documented, Jamie. They're typically documented by way of a side letter or a side agreement to the lease rather than a deed actually varying the lease for two reasons. One, they tend to be temporary concessions, and two, a landlord will typically want the concession to be personal to the tenant, so not capable of assignment in the event that the tenant proposes to assign. From a tenant perspective, I suppose important that these arrangements are binding on a landlord's successor in title, so that if the landlord sells the premises, the new landlord is bound by them. Landlords will typically want to disregard the concession for the purposes of rent review, upcoming rent reviews, and landlords will want to keep the arrangement confidential so that the market and other tenants in the landlord scheme, such as a shopping centre, aren't aware of the arrangement. That contrasts and maybe conflicts somewhat with the tenant's obligation to file the terms of a lease, including rent arrangements, with the Property Services Regulatory Authority. So there's some challenges there. If the lease is registered as a burden on the landlord's title, typically a landlord will want to avoid this concession being registered on the title, again because it's personal in nature and it typically applies for a short period only. So as Colm mentioned, very important that there's clarity around the temporary rental payment terms, what the position is with the accrued arrears, assuming there are some arrears, the period of time for which this concession applies, and the conditions attaching to it, as Colm touched upon, and the position of the circumstances, I suppose, in which the landlord can revoke the concession. They need to be very clear as to what happens in the event of a disposal of either party's interest, confidential, as I say, disregarded for rent review purposes, and very clear also as to the position of a guarantor, if any.
Perfect, Tom. I think there's some very good practical advice there for both sides of the equation to take into consideration in coming to do this deal. I think if you have those points plotted out before you do your deal, it'll certainly make the documentation of it a lot more straightforward and efficient from a time and cost perspective. But I think, again, doing the deal, as we've phrased it here this morning, is with a view in many respects to ensuring that we don't end up looking at these insolvency processes, but inevitably some of them will end up there. And I think most well-drafted commercial leases will provide for such eventualities. And I wonder, would you talk us through what these leases typically say in terms of insolvency arising on the tenant's part?
Yeah, sure, Jamie. I suppose, look, typically a commercial lease will include fairly robust forfeiture provisions or rights for the landlord to terminate in certain circumstances. And those circumstances are typically, where rent is unpaid for a specified period, usually a minimum of 7 days, maybe 14, even 21 days. If there's a breach of any of the tenant covenants, and I stress any, in that's a sort of a concept that is negotiated heavily when negotiating leases, and specifically in relation to insolvency, contractually under the lease, a right of forfeiture arises where a tenant has a winding up petition presented against it, or it passes a winding up resolution, it resolves to present its own winding up petition, or is wound up, i.e. a liquidator is appointed. If a receiver and or manager is appointed, or indeed in certain instances if an examiner is appointed, then that right arises. In the slightly less common situation where a individual is the tenant rather than a company, then similar bankruptcy provisions apply. So if a bankruptcy petition is presented against the tenant, or that tenant is adjudicated as a bankrupt, then contractually under the lease, the landlord has a right of forfeiture. Thanks,
Tom. I think one of the things you mentioned there was I suppose the ability for a landlord to invoke the forfeiture rights in circumstances where a winding up petition has been issued. And perhaps, David, you might talk us through how that process, I suppose, arises, because it's very frequently used as a debt collection mechanism, even though I understand it shouldn't be.
Yeah, good morning, everyone. Good to be with you this morning. Yeah, it is very common for it to arise, Jamie. I mean, there are a lot of grounds to issue a winding up petition. And in particular, any creditor that's owed in excess of €50,000 can issue a petition to wind up a debtor company on the grounds that it's unable to pay its debts as they fall due. And it's important to note here that that minimum threshold of €50,000 grounding the winding up petition was previously €10,000, and that's been increased to 50,000 in recognition of some of the trading difficulties that are arising due to the pandemic.
I think you just David, just to jump in there, the important point, I suppose, in the context of a landlord and tenant relationship for us to, I suppose, factor in is that the landlord's rights of forfeiture in these instances are not contingent upon the landlord issuing issuing the demand. It is, as you say, consequent upon any creditor issuing this against the tenant.
Exactly, any creditor can issue. And I mean, in terms of process, you know, it's very easy to get there. I mean, the creditor issues a statutory demand letter, which is essentially a demand letter giving the debtor 21 days to pay the debt. And then if the debt itself isn't disputed and remains outstanding, then the debtor company is effectively deemed unable to pay its debts. And then the winding up petition can issue on that basis. So then, as Tom was saying, that would then typically be in an insolvency event that constitutes an event of default in the lease, giving the landlord the right to terminate or forfeit.
And I think, again, from a tenant's perspective, what's important there, I think, in terms of the practical implications and the takeaway is that if a tenant is in a difficult position, it's important to be aware not just of the relationship with the landlord, but the relationship it may have with other creditors who might inadvertently trigger a default provision under the lease. And I suppose if we get to that point, can you talk us through maybe a little bit about the various insolvency processes and how they interact with a landlord and tenant relationship under a commercial lease?
Yeah, absolutely. I mean, look, we're all acutely aware at the moment the financial strain that the pandemic is causing, and that can unfortunately ultimately result in both tenants and landlords ending up in an insolvency process. The most common processes that we're seeing that affect commercial leases are where the tenant company is placed into examinership or where a liquidator or a receiver is appointed over the tenant company. So these are all insolvency events that will typically constitute an event of default in the lease. Now, the landlord's or the party's abilities to enforce their rights under the lease will vary depending on which of the processes that applies in the specific circumstances.
So perhaps if we start with examinership, and at the risk of sounding a little bit silly, but like, what is it? Can you break it down for us?
Yeah, so examinership is the rescue procedure available in Ireland for companies that enter into financial difficulty. They're usually the good news stories where the company eventually survives in some form or another. So where a company enters into examinership, it's placed under the protection of the court for a period of up to 100 days. And during this period, no contractual rights against the company can be exercised and no litigation can be issued against the company. So that means, for example, that no action can be taken by a landlord against a tenant company in examinership to repossess the property, even where the lease contains a forfeiture clause. And just in terms of rent arrears owed to the landlord on the prior to appointment of the examiner, that will then be an unsecured debt and will likely eventually be significantly reduced when the examiner puts forward his scheme of arrangement for the company's survival in due course.
So you touched on it slightly there, but can you talk us through what happens to a company's leases, assuming a tenant company has more than one lease while it's under the protection of the court?
Well, for any critical leases that have to remain in place during examinership to keep the company afloat, the examiner can certify the rent due to ensure that it's fully recoverable in priority to all the other creditors of the company. In terms of the company's leases in general, the examiner can't unilaterally vary the terms of those leases without landlord consent, and they'll be dealt with by the company in examinership itself.
Okay, so I think what we're saying is kind of unsecured unless certified. But what happens when moving forward when the company emerges from examinership?
Well, I mean, this is where examinership swings the balance of power slightly more in the tenant's favor. I mean, where the business operating out of a particular premises is not profitable, the company can apply to court to repudiate that lease in its entirety. So that power gives the tenant a really big stick in discussions with their landlords. Landlords effectively need to weigh up the prospect of losing the lease in its entirety, or alternatively agreeing to vary it with the tenant to make it less onerous in terms of, for example, the rent payable or the term of the lease. Now, when a lease is repudiated, there is some consolation for landlords. They'll be able to repossess and re-let the property immediately, and they can, of course, make a damages claim for the loss suffered as a result of the repudiation. However, again, that's an unsecured claim that's likely to be crammed down in the scheme of arrangement put forward by the examiner.
So not a huge amount of good news story there for landlords, David. How does that compare with the liquidation scenario?
Well, I mean, liquidation is the wind down process for a company where it will eventually cease to exist. So, very quickly, generally speaking, a liquidator's job is to take control of the company's assets, to realize those assets, and then to distribute them to the creditors of the company in accordance with the statutory order of priorities. Any claim by a landlord under a lease, whether it's for rental arrears, service charge payments, dilapidation claims, they will all rank as an unsecured claim in the liquidation. And then the landlord will eventually likely receive a relatively small dividend of that claim in due course in the liquidation.
And we have seen instances, albeit probably infrequent, like what if the liquidator wants to keep the property for whatever reason?
Yeah, it is possible that the liquidator will opt to remain in the premises for his own commercial reasons. So, for example, if he wanted to continue to trade or to sell down existing stock in order to actually maximize realizations available in the liquidation, he can do that. I mean, it's important to keep in mind that the fact that a liquidator is appointed isn't necessarily grounds for forfeiture within the first year of the liquidation, even where there is a belt and braces forfeiture clause in the lease that says otherwise, as long as the liquidator complies with the terms of that lease. So, and then in those circumstances where the liquidator continues to comply with the terms of the lease, all rent incurred during that period is fully recoverable by the landlord.
That's an interesting point there. I think that no matter how good a job Tom does in drafting his beautiful lease, the simple fact of the appointment of a liquidator, where that liquidator complies with the terms and conditions of that lease, will not give rise to the right of forfeiture in that lease.
Exactly. I mean, it is infrequent, but in those circumstances, the landlord can't act on the right of forfeiture for the first 12 months of the liquidation. Although, remember, it isn't necessarily bad news for the landlord, as the liquidator has to comply with the terms of the lease. So, all rent has to be paid in full. And if the liquidator doesn't do that, then those normal forfeiture rights and the forfeiture clause arise.
Okay. So I suppose looking then at the more normal situation or more typical situation where a liquidator looks at the portfolio of leases that are there and decides that there's no interest in them, what process occurs then?
Yeah, well, that's the more usual scenario, exactly. So usually, the liquidator wants to avoid any further liability under the lease and instead direct that money into the pool of funds available in the liquidation. So to do this, the liquidator can either surrender the lease or apply to the court to disclaim the lease. And in practice, court applications to disclaim are actually quite rare, as usually a landlord will happily accept a surrender so that they can take possession of the premises quickly and then relet it so as to mitigate any losses.
Okay, thanks. And I think I'm conscious that you've been in the spotlight now for quite some minutes, but if I could get you maybe just to run through the receivership or the implications of the appointment of a receiver on a tenant, supposed to close out the series of processes.
Yeah, well, very quickly, the purpose of a receiver is to realize the property over which he or she is appointed in order to pay the debt as quickly as possible to the secured lender. The appointment of a receiver doesn't automatically terminate a lease agreement. However, the vast majority of commercial leases, as Tom outlined, contain a clause providing for forfeiture in the event that a receiver is appointed. And unlike examinership and liquidation, the landlord is then entitled to immediately re-enter the premises and terminate the lease on the appointment of a receiver. Just finally, in terms of rental arrears under the lease where a receiver is appointed, they remain the responsibility of the tenant, albeit if you think it through, there's probably very little prospect of being paid by the tenant in that scenario where, a secured creditor has effectively moved against the company, which is clearly already in financial difficulties.
Thanks, David. And so, Colm, I think that the guys have kind of teed it up nicely for yourself. So if we can jump over to you. So what we've seen and talked about so far is what the lease says. It's keeping the landlord and tenant relationship alive for so long as possible by doing your deals. And then unfortunately moving into the insolvency processes where there are no real winners. But if a landlord, which our landlord had on for a moment, takes a view that the transaction is heading down that way and we don't want to go there, and I simply want to secure my property before this all kicks off, what steps can a landlord take to secure possession of a property from a defaulting tenant?
I suppose your first port of call is always going to be the lease, Jamie, and just to see what provisions are in the lease that may be of assistance to you. So as Tom was saying there, typically speaking, in a commercial lease, you will have this forfeiture clause, which effectively provides that the landlord can take possession on the happening of a stated event. And again, typically arrears of rent is one such stated event. So provided you have that forfeiture clause there, there's two real options available to the landlord to get back possession. The first is to go down the court route, and the second is to rely on this forfeiture clause or the self-help remedy of re-entry. So if we just consider the two of those maybe at a very high level just for a quick minute, and there's pros and cons attaching to both of them. So in relation to the court route, I suppose the cons potentially of the court route are the time and the cost that's involved in this, which clients often find is a bit prohibitive. In addition to which, you'll often find that the tenant continues not to pay rent for so long as the procedure is going on. And if you look at a typical court case, that could take maybe up to 12 months or maybe longer, depending on the facts. You can see there why that would be unattractive from a landlord's perspective. And in light of those cons, you have to then question what are the pros, I suppose, of going down the court route at all. Well, you get the comfort of a court order that gives you the permission to appoint the sheriff to ultimately take back possession of the property. So it's not something that you're actually doing yourself through this sort of self-help remedy. So if you compare that then to the re-entry procedure, which effectively is the contractual entitlement to the landlord, again, provided it's in the lease. The pros of the re-entry procedure is that it's typically quite fast and cost effective, provided it all goes well. But on the flip side, the risk, I suppose, is the real drawback to re-entry. And the risk that you foresee there is, for example, that the tenant is going to mount a claim after the fact that maybe the re-entry wasn't actually peaceable in the true sense of the word, in the legal sense, or that there's been some sort of business interruption claim. So you really need to be very careful when you're carrying out your re-entry and follow the procedures. And even where you do so, that's not to say that you're going to be completely protected. And in terms of what that procedure looks like, again, typically a lease will say that you need not demand the rent before you do a re-entry. But as a matter of course, and given certain case law, we would always demand the rent in the first instance. And provided that isn't paid, then what you go about is you go about taking back physical possession of the property. And it's that physical act of taking back possession that actually determines the lease. And practically speaking, it's important that you take back possession of the entire property and make it secure in all respects. We've had cases previously where our landlord clients haven't necessarily followed all of our advice and changed the locks, for example, on the front door, and we found then that the tenant has literally come in through the back door over the course of the weekend and taken back possession, and you end up in rounds of taking back possession over and back. And I suppose another key component for a landlord to consider is that what is the nature of the tenant's business here, and what are you going to be potentially left holding after the fact of a re-entry? So we've done re-entries in all classes of business to include hotels, for example, where you can foresee that there would be a number of clients or people staying there. We've also done it in shops and supermarkets where there has been stock left over in perishable goods. And we had one instance previously where we re-entered the property only to find that there was actually a number of marijuana plants on the property, which involved us getting the Gardaí involved. So there's a number of things that you really have to consider before you would engage in that.
I suppose the reference there to marijuana is a useful segue over to Tom. Tom, like in terms of like the leases will often deal with this as well in terms of what's left at a property, either at the end of the term of the lease or if the lease is terminated during the course of the term. Like what can a landlord do? What should a landlord do with those goods?
Thanks, Jamie, for that reference and association. A lease will often say something along the lines of the tenant appointing the landlord as its agent in respect of any goods or fixtures, fittings, furniture, and so on left in the premises beyond, let's say, 5 or 7 days after the expiry of the term or termination. So the landlord typically, or at least has a right under the lease to then dispose of those goods. It has to remit any profits or cash achieved on them to the tenant after it has deducted its costs. But typically, as Colm has outlined, it's very rare that any cash is realised, and it's quite an onerous position for a landlord to find itself in. I think in a retail setting, again, there's been some examples in recent years of the difficulty encountered in retaking possession when there are stock and other items in a store, particularly a department store, where those items might be owned or at least claimed to be owned by third parties like concessionaires and so on. So quite a difficult situation for a landlord to find itself in, and I think extreme caution should be exercised, everything documented and oftentimes recorded by way of video to make it absolutely clear as to what was there when it re-entered and how that's being dealt with.
Thanks, Tom. And Colm, maybe just jumping back to yourself lastly, like I think Tom's mentioned the caution there that should be exercised. Are there any particular types of tenancy or unit that a landlord should be more cautious about, or are there any quirks that should be considered?
Absolutely, Jamie. And again, it comes back, I think, to the nature of the tenant's business. So as I was saying, the example of a hotel, and we've done these, is the hotel occupied, for example, and will you be able to get back possession so that you can secure the premises? Another instance that myself and yourself were working on, you may remember, was a pharmacy, where there was clearly arrears of rent here, but the concern that we would have is that after the fact, we would be left holding all of the stock, and the tenant was not engaging with our prior correspondence, and we foresaw that they would not, I suppose, engage with us after the fact either. And you don't want to be left holding all of that stock, just given its nature. And so, yeah, I think just as much information as we can have in advance of considering this particular option is good. And that's why sometimes you'll find that clients will go for the court route to get the court order so they don't encounter some of these difficulties or risks that you might otherwise have.
Thanks, Colm. So guys, I think we've given a good outline of the backdrop and implications for various insolvency processes on commercial leases. But I'm conscious that we did get quite a lot of questions in, and we'll come to those in a moment. But perhaps we might have some key takeaways first. And Tom, maybe starting with yourself, if you're giving, I suppose, one key piece of advice from today's session, what might that be?
Yeah, Jamie, look, I think the sort of key point from my perspective is around reviewing the lease terms very carefully, first of all, and then early engagement between the parties, between the landlord and the tenant, as I said at the top of the call, primarily to avoid some of the insolvency processes that David has outlined and the end result of those, I suppose, that Colm has outlined for us.
And David, yourself?
Yeah, in an insolvency context, I would echo what Thomas said there. I mean, I would advise making early contact with the insolvency practitioner involved, and demonstrating a willingness to kind of cooperate with them. I mean, the insolvency practitioners operating in the Irish market are all experienced accountants and well known commercially, and they're very commercial and practical operators themselves, so they will reciprocate that. And then other than that, I would just say to properly understand your specific rights and entitlements in the specific insolvency process.
Thanks, David. And Colm, yourself?
I suppose I echo what Tom and David are saying. Early engagement and getting as much information as you can is key, and particularly in the context of trying to dispute or decide which dispute resolution mechanism you're going to employ. If you know, for example, through engagement that the tenant really isn't a mark, then are you actually going to pursue the arrears, for example, through the courts? Are you better off, and is the risk lessened in terms of taking a re-entry? And just to remember as well that there is obviously various reliefs available to a tenant after you would take re-entry, for example, relief from forfeiture. And again, the more information you know from the early engagement will assist you in determining what's the right course of action for you.
Thanks, Colm. And then maybe moving to some of the questions. So we have quite a few questions coming in through the chat function, and we had some of them come in as part of the registration process as well. And we asked people what they wanted to hear, David, and thankfully for you, they wanted to hear from you. So to put you back in the spotlight if I can, perhaps is a CVA in the UK applicable to Irish leases, and is it enforceable in light of Brexit?
Well, we're certainly seeing an increased number of CVAs being proposed in the UK. I mean, unsurprisingly, in retail and hospitality in particular. The procedure itself is obviously governed by English law. It could, in theory, be recognised in Ireland through the EU's insolvency regulations. But in our experience, it's very unlikely that the UK procedure actually applies to properties outside the UK. And just, sorry, in relation to the questioner, I think mentioned Brexit, I mean, that is a point well made. We don't really know what's going to happen in terms of mutual recognition under the EU insolvency regulations. So there's still a degree of uncertainty that surrounds that, and the UK's departure from the EU in general.
Thanks, David. And sticking with yourself, what about the effect of the appointment of a receiver to a landlord? Appreciate that a lot of today's focus has naturally been on the appointment of on the insolvency processes on a tenant. But if a receiver was appointed to a landlord, what effect would it have on the tenant under the lease?
Well, I mean, that's quite straightforward, really. The receiver will step into the shoes of the landlord under the lease. And from a tenant's perspective, its rights and entitlements under the terms of the lease won't vary in the absence of any default. I mean, one point to make there is, again, from the tenant's perspective, where the lease is the subject of a lender's security, it's very important that the tenant has the lender's written consent to the lease and also to any subsequent variations of the lease. Otherwise, the lender and the receiver who's appointed by the lender simply may not be bound by those variations. Thanks,
David. Colm, perhaps one for yourself. In the context of forfeiture, if a tenant pays the rent, is it guaranteed to succeed? So I think that's a relief from forfeiture question.
Yeah, so relief from forfeiture effectively is the court procedure whereby a tenant who's been dispossessed of the property can go into court and look for permission to go back into court. And generally speaking, the courts are loath to refuse that relief to tenants because they don't want a tenant to be dispossessed of potentially a number of years left on the lease. But as part of that application, a tenant will generally either have to A, pay the arrears or rectify the breach that caused the forfeiture in the first instance, or undertake to do so. So while it may be the case that the tenant will be allowed back into occupation, that's going to come with conditions. And you can really foresee, and the case law will show that the only time, I suppose, that the court won't really accede to a tenant's application in that regard is where there's an egregious history or multiple breaches in the past.
Thanks, Colm. And maybe sticking with yourself, Colm, I think you touched on this during your talk as well. In the context of peaceable re-entry, or is a formal forfeiture notice required before that? Or
there is some, I would say, there is law on this, and it's a bit conflicting. So your lease will generally say that you need not demand the rent, but as a matter of course, I always do in the first instance. But whether or not you need to do an actual formal Section 14 notice is another question. So you don't under the law, but you can if you want to. But as I would always do a demand letter. So I suppose the difference between a demand letter and a strict forfeiture notice is that the demand letter in all likelihood won't say that in the event the arrears aren't paid, the lease will be forfeit, whereas that would be standard in a forfeiture notice.
Thanks, Colm. Tom, one for yourself. How are online sales dealt with in a turnover rent agreement? So I think you mentioned earlier on that as part of this, we're all in it together and deals being done, side agreements, deeds of variation, and so on. The turnover rents are starting to feature. I'm certainly seeing it come across my own desk. I think the question here is that in figuring out the turnover, how are online sales dealt with?
Yeah, look, I think it's a fair question and fairly topical, as you say, Jamie, given the sort of increasing shift to online shopping. So, and it is a sort of a bit of a battleground between tenants and landlords when negotiating turnover rent provisions, if they are negotiating them. I think the landlord position will be that the premises, the physical premises, drives to a certain extent online sales, and that on that basis, the landlord should get a piece of the action, as it were, in terms of the online sales contributing to the turnover rent. A tenant will obviously have an opposing view and say that their online sales are something entirely different. So look, no one size fits all answer to that question, but it's certainly topical and a matter for negotiation between the parties in each set of circumstances.
Thanks, Tom. And again, I think there won't be a one-size-fits-all answer to this question, Tom, but does the creditor petition itself trigger the event of default under the lease, or is it dependent on whether the petition is successful? I think that's going to depend on the lease, Tom, and how it's drafted.
Yeah, absolutely. I would agree. And while the lease provisions can say a certain thing, the insolvency process, as David has outlined, can change that in certain circumstances. But you will often see the petition itself being a trigger for forfeiture, but that's on the contractual basis under the lease only. And you are subject to the insolvency rules and law, as David has outlined.
Thanks. And David, maybe coming back to yourself, if we can maybe just get a bit of jumping back to disclaimer and liquidations. So the question is like for a liquidator to formally disclaim the lease, is a court application required? Or I suppose, is there a difference between a formal disclaimer and what actually would happen in practice for the reasons you outlined?
Well, as I mentioned, where the landlord is willing to accept a surrender, clearly there's no requirement then to apply to court to formally disclaim. However, oftentimes it may not be as straightforward as that. The landlord may have his own reasons for refusing to accept a surrender. A guarantor may be in the picture as well. So there's kind of a lot more behind it, and in those circumstances there is an obligation on the liquidator to then apply to formally disclaim, or to seek leave from the court to formally disclaim, but it can vary depending on the specific circumstances.
Okay, thanks, David. So I am conscious that we have a couple of questions that we haven't got to, but that we're up against it on time, so rather than rush through them, I think we might wrap it up there, guys. So Tom, David, and Colm, thanks very much. Hopefully everybody tuning in learned something today, and thanks for taking the time and the interest to do so. We will, if we haven't got to your questions, try to get to them and come back to you. And if you happen to have the time, please do fill in the survey, which our events team will fill out and tell us either how well we did, or actually don't bother if you didn't think we did, but also do let us know if there's anything else you'd like to hear from us on. So thank you very much.
Thank you.